Good evening, everyone. My name is William Reichman. I'm the Special Magistrate appointed by the City Commission of the City of Deltona to hear cases this evening where the City of Deltona has contended that there are violations of the City of Deltona Code. These are code violation cases. First, we have an agenda, and the first thing on the agenda after this call to order is a roll call where I'm going to ask the members of staff, the code enforcement officers, will go around the room to identify themselves. Again, I'm the Special Magistrate. I am William Reichman. So I'm going to start to my right with the gentleman to my right.
My name is Officer Gibson. I'm City of Deltona Code Compliance Supervisor.
Byron San Miguel, hearing clerk.
Kristen Coulter.
Code Compliance Officer Tyler Russo.
Code Compliance Officer Bashir Turkzi.
Code Compliance Officer Dennis Muse.
Code Compliance Officer Todd Mead.
Code Compliance Officer Jamari Millender.
Richard Lovett, Code Compliance.
Ron Paradise, Community Services, City of Deltona.
Thank you, folks. So everyone could please stand and pledge to the flag. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As you can see, if you did pick up a copy of the agenda, the next thing is just a very short statement on my part to let you know exactly how these cases work. These are public hearings. Those are different from public meetings. In other words, the people that have an interest in each case are going to get the opportunity and will have the opportunity to tell me what I need to hear in order to render a decision tonight. That decision will ultimately be put into a written format in the form of an order, and that will be sent to the city as well as to the respondents on the cases that are on the agenda this evening. These hearings are called quasi-judicial, and what that means is that we don't follow strictly the rules of evidence that are in the Florida statutes. It's not as formal as that, but we do have to provide for mandatory due process. And what that means is that the statute requires that you receive, or at least certain notices have been sent out. You will have the opportunity, if you are present tonight on your case, to tell me, to testify, to under sworn oath, what you want me to hear. You have the right to see any exhibits, if there's photographs or videos or whatever that are being displayed or provided to me by the City of Deltona staff. If you have witnesses and you wish to have them present testimony, they'll get sworn in as well and they can testify. Just so you know, everything today is being recorded. You can probably hear the gentleman in the back, 10987. That means that this is being recorded, and that's for everyone's protection to make sure that there's no guessing about what was said, what was heard, what was done. Your testimony will be under oath. We'll swear everyone in just a second. There is not a public comment section. This is again not legislative. We're not making rules here. We're just applying the rules to certain facts. That's why it's called quasi-judicial. So if you want to testify, you have to have a case on the agenda tonight to testify. In each and every case, the city will be obligated to go first, and they'll be obligated to prove that there is a code violation. They have the burden of proof, and at that point in time, when we call your case and the city goes and presents and they're done, then obviously I'm going to hear from everyone that's here tonight and on your case. There is an agenda. I believe copies were provided to you or available to you at the back desk there, table. And there's some minutes from the last meeting. I've reviewed the agenda, I've reviewed the minutes, and have approved those. We're going to get everyone sworn in a second. Do I need to announce the cases that have been continued or withdrawn? Anybody? Or is that something that you check to make sure that there's no one here waiting for their case that's been withdrawn or continued?
No, sir, it's been checked.
Okay, very good. I appreciate that. All right, so we're going to go. The way this works is first come, first serve. It means if you got here first and you were signed in first, then we're going to take you first. It's only fair. So at this point in time, I'm going to ask everybody who may present testimony to me this evening to stand and raise your right hand so we can swear you in. That's going to be all the code enforcement officers and all of the folks that are here tonight on their cases. If you stand and raise your right hand. Do you swear or affirm that the testimony you'll provide tonight will be the truth, the whole truth, and nothing but the truth? Again, folks, have a seat. When your case is called, and I'll make it real clear, I'm loud, that it's your case. Remember, it's on a first-come, first-served basis. The city goes first. They step to that podium and say what they need to say. And then when they're done, then that podium, will be to your right, was where you need to come forward. When it's your turn, when you come forward, what we need is for you simply to give us your name and your address. And the reason we're doing that is because the record needs to reflect who it is that was here, who testified, for identification purposes. So with that, the first case that we're going to have tonight is 22263. The address is 2923 Clovis Drive. Deals with a pool issue, and it's Officer Russo.
Good afternoon, Mr. Reichman.
City ready to proceed?
Yes, sir.
Please do so.
My name is Tyler Russo. I am employed by the City of Deltona as a co-compliance officer. This will be case number DEL 22-263, the City of Deltona versus Ronald Acker. The property address is 2923 Clovis Drive. The parcel ID number is 813-041-410-050. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 303.1, which states that swimming pools shall be maintained in a clean and sanitary condition and in good repair. The corrective action for said violation is for the pool to be maintained and either drained of water, or water must be chemically treated to remove algae. Water should be clear water and sanitized. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. On June 22nd, 2022, a complaint came in about a pool in the backyard of a home that was very unsanitary. When I first initially made contact with the resident of the home with the unsanitary pool, the woman informed me that she has been in the process of trying to get someone out to get the pool clean for her. I asked if she was currently working on the pool to get it cleaned up, and she told me not as of right now. I decided to give her a few weeks to get it cleaned up, and then asked the woman if I was able to take a picture of the pool for documentation, but she never gave me a clear yes or no answer. I took what she said as a no to getting a picture of the pool, so I proceeded to go to the complainant's property and ask if I was able to take a picture of the pool. He granted me access to the property so I could take the picture. After the courtesy time period was up, the pool had not been cleaned, so I proceeded to post the violation on July 22nd. Since this violation has been posted, there has been no indications of the pool getting cleaned. As of today, the pool still remains unsanitary. The city would like to request 7 days for the property to come in compliance, or a fine of $250 per day to be imposed until such time that the property owner has been notified the city of compliance.
Thank you, Mr. Rousseau. Is there anyone here this evening on this case? This is DEL 22263. The property owner is Ronald Acker. Again, the property address is 2923 Clovis Drive. Is there anyone here this evening on that case? Let the record reflect there's no one here. I'm going to find that the property remains in violation, that the property owner did receive all required statutory notices. I'm going to provide in my order that there will be 7 days to comply, or a fine in the amount of $200 per day to be imposed. I do have this question for staff. Is the pool secured?
Yes, sir, it is. It has a fence around the property.
Okay, just wanted to make sure, because if it was different, was unsecured, obviously I'm sure there's children in the area, and it looks like there was a cover on it, that could be a problem.
Correct.
Okay, so again, still in violation, 7 days to comply, or a fine of $200 per day.
Thank you.
What's our next case? Sorry, what is it? Okay, the next case is 22336 731 Nardello Drive. Just give me a second to get there, folks.
Good afternoon, sir.
Hang on just a second. Oh, page 18. I'm sorry, I didn't hear you. Thank you. That's what you were trying to tell me.
They are right in the right-hand corner.
Fantastic. Thank you very much. I get it. All right. 336, the property address is 731 Nardello Drive, property owner, I believe it's Mr. Sanchez. The city ready to proceed? This is a roof issue.
Yes, sir. My name is Bashir Turkzy. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22336, City of Deltona versus Valentin Miguel Angel Sanchez. The property address is 731 Nardello Drive. Parcel ID number is 813-020-09-0010. This violation of City of Deltona Ordinance Section 18-5, which adopting the latest edition of the International Property Maintenance Code Section 304.7, which states the roof and flashing shall be sound, tight, and not have any defects that admit rain. Corrective action for said violation is to repair or replace the roof, gutters, or drainage. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was a proactive case that was opened on February 14. Regarding a roof in disrepair, a notice of violation was posted on June 28th, and the resident was given until July the 8th to address the violation. I've spoken with the property owner on several occasions and advised him of corrective actions. Mr. Sanchez had informed me recently that he had reached a settlement with the insurance company and is awaiting receipt for the funds to repair the roof. As of today, the property is still in violation. The city would like to request 30 days for the property to come into compliance, or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance.
Anything further?
No, sir.
Is Mr. Sanchez or someone here on behalf of 731 Nardello Drive? Sir, if you could just come forward, and again, for the record, if I could just get your name. I think I know who you are, but for the record, if you give your name and your address, please.
Hello, good afternoon to everybody. My name is Miguel Sanchez. I'm the homeowner of the 731 Nardello Drive.
So where are we on this property, Mr. Sanchez?
My insurance, my property, can I lift this a little bit? Thank you. The insurance of the house is being given a hard time. After submitting the claim, they're rejecting 4 occasions, and finally I find a company with they assign me an attorney. Sorry, my English is not the best. And this attorney was wonderful. So she finally get a settlement from the insurance. So we got a settlement for the funds to replace the full roof, which I'm very happy today, even that I'm here. So I have the proof that I signed the contract with the roofing company.
Okay.
They told me they have to wait a couple of weeks because the situation, they're running behind in materials.
Okay.
But the funds are there, the roofing company contract is already signed, and I'm ready to go with the roof, which I'm very happy though.
Well, it sounds like
he's been very kind with the situation.
Right.
Thank you, Bashir.
Oh, they're good folks here. Sounds like that things are moving in a good direction for you.
Oh, yeah, awesome.
What the gentleman is saying from the city of Deltona is that, and what he's asking for me to do is enter an order that gives you 30 days, Mr. Sanchez, to get the roof fixed.
Okay.
And we're not here to punish you. We're not here to penalize you. This isn't about making money for the city of Deltona. That's not how the city of Deltona pays its salaries.
Understood.
But we do want to create some sort of incentive for you to finish, get the work done, get the, for yourself, for the roof, for your neighbors, et cetera. So my question to you is 30 days, is that something you think is reasonable from your end of it in order to get the money, you got the money, get the roofer going and get the roof fixed?
Well, to be honest, I'm not the experts in the roofing industry, but the roofing company guy, they working right now on I signed the permits for them to go to the county to report that they're going to be working on that property. I signed that document 2 days ago. So they're working on it, but they cannot guarantee how long it's going to take for them to get the whole materials on the top of the roof to start working on it. So I don't know, to be honest, I don't know if that's going to take 1 month more or maybe a month and a half or 2 months. I'm not sure, to be honest.
Well, I'm not asking for a guarantee, but again, I need to put some reasonable deadline on this.
What about 2 months? I mean,
What does the city have to say about that?
We're okay with that.
Okay.
Thank you for sharing.
All right. So here's what I'm going to do, and this is why we have these hearings, is so we can try to make something, we come to some resolution that's fair and reasonable.
Awesome, thanks.
Because that's what we're trying to do. We're trying to get all the properties in Deltona looking good, income code compliance, but do it in a way that
Totally agree.
that makes sense.
Yep.
So I think we all agree that the property, right now is in disrepair and there's a code violation. I'm going to find that 60 days is a fair amount of time for
Yep.
you to complete this project, get that house in repair. Or if it's not at the end of that 60 days, and this is the lever, this is the
Okay.
is the penalty, it would be $100 a day fine if it's not. So and we don't want that. I don't want it. He doesn't want it. We don't want
Absolutely
that. You don't want it.
No.
So what I need for you to do, as soon as this roofer, this contractor finishes the job, you need to contact this gentleman right here.
Bashir?
Okay?
Okay.
And let him know that it's done, and then we're done.
I mean, I would like to ask, based on your experience, guys, do you think 2 months is going to be, with this inflation and this situation, with, that everybody go through it, are you going to get that materials?
We cannot exactly tell you how long it's going to take. We'll just stay in touch with the insurance company and
Well, I think, and again, I'm not your attorney, but I'd recommend that you keep this in mind. It's going to be 60 days from today, and what you want to do is you want to get on the phone tomorrow morning with your contractor.
Okay.
And let him know that this is not one of these deals where he can get to it whenever he can get to it.
Okay.
In other words, you need to kind of light a fire under him, your roofer. Get him started as soon as he gets the materials.
Yeah, because the reason of the tarp is because the first leak was in the porch, but
Sure.
then a new leak come up in the middle of the living room. So no one else
We
is
get it.
more desperate to get a new roof than me.
I hear you. And you're here tonight, that makes a big difference for all of us. That's important to all of us.
Thank you.
We know that we've got a teammate trying to get this thing fixed. So
Absolutely.
60 days, please keep in touch with this fine gentleman right here, and then hopefully, well before that time, you've got a new roof and no leaks in your living room.
Hopefully.
Okay?
Thank you.
Take care of yourself,
I
sir.
appreciate that.
Yes, sir.
Thank you, sir.
Thank you.
Thank you. Yeah. Stay in touch.
Next case is DEL 22115. It's a Massey case, 832 Merrimack. Hang on just a second. Page 11. It's a permit issue again, 22115 Massey, 832 Merrimack. City ready to proceed.
Yes, sir. My name is Kristen Coulter. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 22115, the City of Deltona versus SFR XII, Orlando owner 1LP. Property address is 832 Merrimack. Parcel ID number is 813-0300-50170. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on May 11, 2022, that the property owner was given 60 days to comply. The owner did not come into compliance within those 60 days and has been receiving a fine of $50 a day since July 11th. As of today, the property has accrued a total fine of $2,250 over 45 days. I will note that the property owner is attempting to submit an application for a permit. They're just having some issues with that.
So this case is about work that was done without a permit.
Yes,
Went to hearing, didn't have a permit at the time of that hearing. So an order was entered saying that you had to get the permit within 60 days.
correct.
Didn't get that in the 60 days, and here we are at the Massey hearing, and it's indeed been 45 days past that 60-day deadline at $50 per day pursuant to the prior order. Okay, for a total of $2,250. Now, tell me a little bit more about what's the status of progress? What progress is being made, if any?
So on July 21st, they submitted an application to cover all the no permit issues that we have open. They had some technical difficulties with submitting that permit application. It has since been voided this week, so they're working on resubmitting a new application.
So is there pending an application for the necessary permits, or has that application been voided?
So the one that they submitted has been voided. They have not yet submitted a new one, to my knowledge.
Okay, thank you very much. Is anyone here for the property 832 Merrimack Street, and it looks like it's an LLP? Yes, sir, please come forward. I need your address and what's your relationship to the property owner.
Good afternoon. Danilo Martinez, 1237 Lake Baldwin Lane, Orlando, Florida, 32814. I'm a project manager for the owner, which is Tiber Capital.
Okay, I've got the owner as SFR 12 Orlando, is that same?
Correct. That's how they buy their properties.
Okay, all right. And you're basically in charge of the work, including what would be the permit?
Not to do with this project at all. I was thrown into this with only a few days' notice, so I do apologize for that. I have limited information, but based on what she has shared, she is correct. There were some technical issues in the permits when they were filed. Penny Bolt, that has been in contact with Mrs. Coulter, is in the process of requesting the new permits because the original application was voided. That was as of this morning. They were in the process of issuing those permit application requests as well, so.
But right now, as we all stand here, the property's still in non-compliance because we don't have the permits issued.
They are not officialized or requested as of yet.
Okay.
They're only in progress.
And you understand, I hope the owner understands that the fines are running at this point, $50 a day.
Yes.
Okay.
If I may?
Yeah.
What was the total? You said $2,250 at the moment?
$2,250
Okay.
plus, and then it'll be $50 a day.
Okay.
So I'm just curious, what do we look, if they submit tomorrow, what are we looking at as far as a time frame? If they submit an application that's complete, what are we looking at for a turnaround?
If I may reach out to Mr. Love.
Yeah, turnaround's about 7 days.
And where is the company or the owner in regards to submitting an application, given the time frame we just determined?
According to Penny Bolt from our permitting department, she was in the process of doing that today. That should be at least in progress by the end of the week, I imagine. A period of 1 to 2 weeks, if it's fair with everyone, as a continuance or an extension, if I may request that.
Well, I'm not inclined to do that. What I am inclined to do is reduce the fine that's due today, but I do want to keep an incentive on the owner, not you. You're here on behalf of the owner, but I mean the owner is the one that caused you to have to be here tonight. So what I'm going to do is I'm going to find that the property remains in noncompliance. This is a Massey case. In other words, all we're doing tonight is not arguing about whether the property's in violation or not.
Correct. I'm not arguing either. So.
I know you're not. I know. That was just a figure of speech. And I'm trying to create and maintain an incentive for the property owner to do the right thing, which is comply with code. So I'm going to reduce the fine to $1,500. That's basically $750. So that's a pretty good deal. That's at $50 a day. That's almost 2 weeks. So that's kind of giving you what you've requested, which is a continuance. But here's my point. I'm reducing the fine that I could impose today from $2,250 to $1,500. That's the fine as of today. The fine will continue at $50 per day. So the sooner that the owner gets the permit in, or gets the permit, quicker that $50 per day fine is going to end. Okay?
Yes, sir.
Okay, so it's $1,500 today, and then it's running at $50 per day. Okay?
Very good.
And I appreciate you being here. Please work, and this is important. As soon as you guys get what you need with the permit, this young lady right here needs to be told.
Yes, sir.
Okay? So you have her contact information.
I do, yes.
Okay, we good?
So this is one of 4 total cases, 4 no permit cases. that
Oh.
were- Yeah.
Okay, you're right, I didn't see that. Okay, all right, so that's the first one. The others are permits as well, apparently. Oh, boy. Okay, all right, let me have the next case then. I've got a feeling we're going to be saying the same thing. Okay, 22116 Massey. I'm glad you didn't sit down, sir. This is the same address, same property owner, and apparently this, again, it's a Massey case, so it's the same matter. City ready to proceed?
Yes, sir. My name is Kristen Coulter. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 22-116, City of Deltona versus SFR XII, Orlando owner 1LP. Property address is 832 Merrimack. Parcel ID number is 813-0300-50170. The statutory requirements for notification of this hearing have been met by notice of hearing and notice of code violation sent certified mail to the property owner at the property address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on May 11, 2022, that the property owner was given 60 days to comply. The owner did not come into compliance within those 60 days and has been receiving a fine of $50 a day since July 11th. As of today, the property has accrued a total fine of $2,250 over 45 days.
I need to understand this a little bit better in that I need to know why this is a permit case. Why is we got 4 of them.
Correct.
What is this? What makes this different from the last case as far as?
So there were 4 different renovations of sorts that were done without permits. So the 115 was for the support beams, 116 was for the new windows, 117 was for walls, and then 118 was for new
And they all
doors.
require under the Land Development Code and the
Correct.
Florida Building Code a separate permit. Okay, sir. If you want, all you need to say is ditto.
Correct. As, in the interest of saving time, the remaining cases will be the same
Okay.
outcome and the same results.
Okay.
So,
And I'm going to make a suggestion. This is, and you're here on behalf of the owner. With the remaining cases, I am inclined to reduce the fines to $1,000 for the remaining cases from the $2,250. So it's still a lot of money. I get that. But this has been a violation that's been going on. It's not your fault. But the owner knows about this and has known about this for months
correct.
and dropped the ball. And the city's entitled to move forward on these cases. In fact, it's obligated to move forward on these cases. So I'm inclined to give the owner a break somewhat and reduce the fines in each of the next cases, assuming the other 2 cases are identical to these.
They
Is that
are.
correct, for the record?
Yes, they are.
And I'm hearing you say you agree that the next 2 cases are identical to the first 2.
Yes, sir.
I'm going to reduce the fines for these last 3 cases to $1,000 through
you.
today for the 3 cases, continuing at $50 per day. So again, the incentive is the sooner they get in and fix that, it's basically $200 a day because it's 50 times 4.
Yes, sir.
Are you agreeable to that?
Yes, sir.
Okay. That's going to be my ruling on this case, which is 22116, 22117, 22118. I'll prepare separate orders for each of these 4 matters and these 4 cases. And again, I can't emphasize enough, if you would contact this fine young lady as far as soon as you can get in compliance, and I'm sure the city will work with you to make sure that these fines stop as soon as possible.
Yes, sir.
Okay? Very good. Thank
Thank you very much. I
Thank you for
appreciate
being
your
here tonight.
Thank you.
Let me write down some notes. It's $1,000 through today. Still in violation. $50 per day. Okay. Thank you. Okay, the next case, DEL 22337, 930 Sweetbriar Drive. Officer, oh, I'm going to mess this up. I always do. Turksheet. This is something about outdoor storage.
My name is Bashir Turksy. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22337, City of Deltona versus Guy H. Antoine. The property address is 930 Sweetbriar Drive. The parcel ID number is 813-066-100-130. This is a violation of the City of Deltona Ordinance Section 38-114, which states that storage of building materials, commercial and industrial equipment, materials, objects, or waste relating to commercial and industrial uses, or any equipment, materials, or objects that are not incidental to residential use shall be prohibited. Corrective action for said violation is to remove items from the property. The statutory requirements for notification of this hearing have been met by the notice of hearing and a notice of code violation being sent, certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was opened on June 13th in response to a complaint concerning debris and outside storage at this property. A notice of violation was posted on June the 27th, and the resident was given until July 7th to address the violations. I have spoken with the property owner several times and advised him of corrective actions. Upon reinspection today, the property was still in violation. The city would like to request 7 days for the property to come into compliance or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance.
Thank you, sir. Is anyone here on 930 Sweetbriar Drive? Mr. Antone? Yes, sir. Could you please come forward, sir? And again, if you could, just for the record, I need your name and address, please.
Good day. My name is Guy Antoine. I'm here to represent 930 Sweetbriar Drive.
Okay. And if I could ask a favor, if you could just make sure, so I can hear you, if you could speak right into the microphone and please be louder. Thanks.
Sure.
So you've heard the city's position. What do you have to say?
I tried to comply as best as I could as far as moving the debris that he considered debris. I moved them. I got rid of all the garbage. But the rocks, they're there to finish that portion that you see with the wood right in front of the fence. They're going to be thrown there. I recently started a new business, so my time hasn't been as ample.
Are you doing this project yourself?
Yes, sir.
My condolences.
My time hasn't been as ample as prior to where I did the other side and completed the other side already. So the bag of sand, I can't move it because I need a machine to move it.
No, you just use it until you can move it.
Right.
I get it.
The rocks also, I use a bunch of them already, but they're still,
No, I get it.
I'm not ready to throw the rocks
How
until
much longer do you think you need, sir?
I actually, to comply, I spoke to a contractor to see if they would come and finish it for me.
Right.
But it's hard for me to swallow $5,000 where everything that belongs to the house runs through there. Sprinkler system, electric. I recently, if I would have fixed it when I was asked to fix it, and right away and just dropped my business and just did that, I had ordered an electric car. I took delivery of the electric car after I was told to comply. I would have had to break it again with the $5,000 to run power to where that power that you see right there, I would have had to break it again to put the plug for the car. So I would have been $10,000 in contractors to comply right away. But now I've taken delivery of the car. If I have to take the $5,000 hit to have it completed, I would. But if a water main were to break again like how it did in January, I would have to break that $5,000 again. And the city doesn't help me with any of that.
You keep saying you're going to have to spend another $5,000. Is that because you might have to pick up the
I would have to
pavers?
break it all, pick it all up, and I've done this twice already.
All right, let me ask a question of the city. If you could bring back the photographs of the debris that's on there. What's there today? You said you went out there today, officer.
Correct. I have a picture of.
Just leave that up right there.
taken today.
Leave that up right there. Right.
No, is that today? No.
Well, that's exactly how it looks today,
Yeah.
actually.
Yeah.
It looks
It's
just like that,
the same
just
thing,
rocks
yeah.
and a bag of sand. That's today.
And that's what I'm trying to pin down. I'm trying to pin down right now what's out there today. And there was a photo of that somewhere in there, there's a photo of, looks like construction materials.
Correct.
So is that what you saw today?
Yes, sir.
Because he's saying most of it's gone. I'll make sure that's true. Most of it's gone except for the sand and the stones and the construction
And the
materials.
stones, that's it. There's nothing
And I get
there
that.
today other than stones and the bag of sand.
Right, and I get that. I'm just trying to make sure we're all on the same page.
Okay.
That's all, sir.
Sure.
Okay, and he's saying, you know, this is what happens when, and I've done it, where you try to do something yourself, and it never goes the way that you expect it to go, ever. And yet, we've got a code violation.
I agree with him. I don't disagree.
Yeah.
You know, I don't disagree.
So
at
I'm
all.
trying to find a good solution for the city and for you, sir.
Okay.
You've been listening, you've been paying attention, you see what I'm trying to do here. I'm trying to do what's fair, but at the same time, this has been going on a while.
Yes, sir.
So he's saying 7 days. What do you think you're going to need to finish this, or get somebody to finish it for you? And don't tell me a year, okay? Because you're not going to get that.
Well, I would also like to take into consideration, the house is being painted. They started painting today. You can see that the lights are missing that were in previous pictures right under the camera. So the house started getting painted today. They should be finished by Friday. The contractor that I spoke to finish that side, he said he could get going as soon as next week. But I would rather do it myself, so.
Well, I'll leave that to you, okay? That is not my call, but I am asking, I'm trying to make sure it's reasonable. Now, what you've just described is if you use the contractor, what I'm hearing is about 10 to 14 days.
Yes.
Most likely.
Yes.
If you do it yourself,
It's like a month.
Yeah, so I'm trying to.
Realistically, a month.
Okay,
if I do it
so
myself.
that's what I'm driving at here. All right, so he's asking for a month. What does the city say?
We're okay with a month.
Okay,
Yeah.
fair enough. See?
you.
So we're gonna, so I'm gonna, you're still in violation,
No, I
obviously.
know.
Yeah, and you're here, and that's great.
Thank you for.
Yeah. We're not, this is about just getting the property in compliance and doing it in a reasonable fashion. That's what we're here.
Park the car there now.
Yeah. So I'm going to give you a month. We're going to give you a month. And then if it's non-compliance, then it's a $100 a day fine. That's not, again, I'm going to say it again, that's not what we're here for, is try to impose a fine. But that's the tool that the statutes give us to try to bring the property in compliance.
Yes, sir.
So good luck. Next time, you probably want to go ahead and just, call the contractor in the first place. But I understand. They're expensive these days.
Yes, sir. Yes, sir.
Okay?
Thank you.
All right. Good luck.
Thank you.
You bet.
Thank you, sir. Mr. Reichman, if I might add, there's two DEL numbers for the same case. One of them would for debris and the other one for outside storage. It's for the same violation. I just wanted to
This is
just
what?
make you aware of that.
So I just did 337. What are the others?
338.
Okay, let me, and just the one, 338?
Yeah, it is the same, it's for the same violation. It's just one of them covers debris, which was included in the outside storage.
He's here. Why don't we do this? This is my suggestion. It's up to you, but you could continue that case and just see where you are in 30 days.
Yeah, that is fine. That's, yeah.
Is that okay with the city? Okay, so I'm going to continue 22338. You understand what I just did, sir?
Yes, sir.
Okay. Again, if you get this into compliance, when you get this into compliance, within the 30 days, you just let this guy right know, and then we're done.
Yes, sir.
Okay.
He comes around often.
Okay, you guys are buddies. That's good. I like to hear that. All right. Good luck.
All right, sir, thank you.
All right.
Thanks.
Thank you again.
Okay, the next case is 22256, Dangerous Dog. This is at the property address is 1542 Fort Smith Boulevard, and the property owner must be the owner of the animal is Benjamin D. Adams and Marie T. Adams. So this is an appeal. This is an appeal, folks. Go ahead.
Okay. My name is Kristen Coulter. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-256, the City of Deltona versus Orlando Figueroa Jr., Benjamin T. Adams, and Marie T. Adams. The property address is 1542 Fort Smith Boulevard. The parcel ID number is 813-07-222-0220. This is a violation of City of Deltona Ordinance Section 14-166B. A dog is deemed dangerous if, according to code enforcement records, and the definition under Section 14-1, dangerous dog means any dog that, according to the records of appropriate authority, has aggressively bitten, attacked, or endangered, or has inflicted severe injury on a human being on public or private property, has killed a domestic animal or more than once severely injured a domestic animal while off the owner's property, has been used primarily or in part for the purpose of dog fighting, or is a dog trained for dog fighting, or has, when unprovoked, chased or approached a person upon the streets, sidewalks, or any public grounds in a menacing fashion or apparent attitude of attack, provided that such actions are attested to in a sworn statement by one or more persons and dutifully investigated by the appropriate authority. Corrective action for said violation is to comply with the statutes pertaining to dangerous dogs. The statutory requirements for notification of this hearing have been met by the notice of hearing were sent certified mail to the dog owner and property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On July 11th, I was dispatched to 1539 Fort Smith Boulevard in reference to a dog attack. Upon arrival, I made contact with the victims of the incident, Kitsia Perez-Caban, her 2-year-old son, and her mother. Ms. Perez-Caban stated that the 2 dogs reside at 1542 Fort Smith and crossed Fort Smith Boulevard and chased her and her son on the night of July 10th while she was taking out the trash. I was able to view the doorbell camera footage of the incident showing 2 dogs crossing the road and entering the property of 1539 Fort Smith in an aggressive manner. The video shows the victims running away from the 2 charging dogs and falling down in the process. Multiple injuries were sustained by the victims during the attack, including a broken wrist requiring surgery, a dog bite, a fractured finger, and a broken tailbone. Ms. Perez-Caban stated that she was bitten by one of the dogs on her ankle, and a bite report was filled out and sent to the health department. Contact was then made with a young man named Jason at 1542 Fort Smith, who was claiming guardianship of the dogs at the time. He was informed of the 10-day quarantine required of the dogs and was unable to provide any rabies vaccination history. I let him know that I was initiating a dangerous dog investigation at that time. On July 14th, I received an affidavit written by Ms. Perez-Caban detailing the events of July 10th. On July 20th, I cleared the 2 dogs, Athena and Smokey Mar, from their 10-day quarantine. At this time, I hand-delivered the initial dangerous dog letters and made contact with the dog owner, Orlando, and issued citations for the dogs being at large and for mandatory spay and neuter. Because the 2 dogs chased the victims in a menacing fashion, bit Ms. Perez-Caban, endangered a young child, and approached the victims in an attitude apparent of attack, resulting in bodily injury to 2 victims, a determination has been made that there is sufficient evidence under city ordinance to classify and declare the 2 dogs as dangerous.
Does the city have the victims here?
Yes.
Could they come please forward? Ma'am, if you could give me your name and address, please.
Oh, my home address or my mom's address? Or,
Whichever you address, just an address where you can receive correspondence.
1709 Providence Boulevard.
Could you tell me, in your own words, what happened on, let's see, what was the date? July 10th?
So I visit my mom often because we have a special needs son. I do, sorry. Me and my son's father do. I was taking out the trash and my son walks behind me. My mom saw the dogs outside. They had no leash. They were not responding to any verbal commands.
When you first saw the dogs, were they on your property?
I did not see them. My mom saw them from across the street. They were not on our property, on her property yet. My son and me were on her property. I'm walking towards her garage because her trash can is right next to her garage. My mom saw the dogs running across the street. For some miracle, there was no cars coming through that night. The dogs came running towards my 2-year-old. I quickly reacted. My mom went to grab my son, ran. I went to grab him because the dogs were coming towards him. The dog made contact with one of my ankles. I pushed the dog away with my foot. I kept running. I grabbed my son, held him against my chest and held his head. We ended up tripping. Dogs are still behind us, still chasing, still barking, still being aggressive.
Where were you when all this happened?
At my mom's house. It's all caught on video. It's in front of her house. The dog owner
Do you have that
absolutely
video
no
that we could play?
response to it.
Okay, let's go ahead and play it. Let's play the video. That's your son.
Yes.
That's your mom, your son, and that's you.
That's her partner.
Okay. Okay, that's helpful, thank you. So the city's made the determination that the dog meets the standards and that under the statute, under the code, to be declared a dangerous dog. What is, in that order or in that determination and finding, were these dogs to be put down, or were they simply to be declared dangerous and treated accordingly?
To be declared dangerous and treated accordingly.
Okay, is there anything further from the city?
No.
Those are the two animals right there?
Yes.
Let me ask ma'am, what happened to you as far as your injuries? We need to get that for the record.
I broke my wrist. I do need surgery. I am going to have surgery next Friday. I will need 2 screws and a wire put on permanently. If it does not heal, I will need a second surgery for it and permanent damage on it for forever.
Okay. All right, thank you very much.
My son is safe, so.
Yeah, please don't go far. This is an appeal, so I need to hear from the other side as well. So if you go ahead and have a seat, if the city officer, if you could sit down, and then I'm going to ask for the individual, I guess it must be the dog owner, who has come forward and tell me what you want me to hear, sir. I need you to identify yourself.
Orlando Figueroa, 1542 Fort Smith Boulevard. I'm not sure too much about what went on that night. I was out of town in Eustis, Florida, doing a job. I have a home improvement business. So as far as what happened, all I know was the phone call I got. I get dropped off to my jobs. I've just got my driver's license back on Thursday. So to get back and forth to even talk to anyone, that's been pretty difficult.
Are these your dogs?
Yes. The female, Athena, she was gifted to me by a friend of mine. I've been trying to contact his sister so I could get her records. The male, Smokey, his shots were done by the breeder and myself.
Do you know who that gentleman is in the video?
In the tank top?
Yep.
No, I've only had bare minimal contact with them since they moved to the neighborhood. I think I helped to get a fridge inside the house.
Do you know how your dogs were running loose that evening?
From what I know, my nephew went to take them out, didn't get to leash them, and they seen the kid My dogs go to the park all the time. They play with kids. They play with the dogs there. They ran across the street because they seen a kid.
Okay.
Thank God they didn't get hit, because that is a very busy street. I've lived there a long time, 9 years. I've had 4 pit bulls in that house before, a whole family. None of my dogs are aggressive. Only aggression is when they're trying to get pet, they're pawing at you. Only evidence I would have of how friendly they are the videos and pictures I have on my phone where they play with my niece and every other kid.
Okay, thank you, sir. I need to ask a question for the young lady again, who was injured. If you could come forward and give me your name again, please, for the record. Video was dark, so it was really hard for me to tell exactly. You know, it's either, must be early in the morning. I mean, I saw what happened to you, and I see the dogs there. Can you,
This was late at night.
it was late at night, okay,
Yeah.
but I mean, it was dark, so it's hard to see from the ring camera exactly what happened when they were running across the street. Tell me what you saw when you first saw them, ma'am. What were they barking? Were they not barking? Were they, what did you think was about to happen?
Whoever was outside the house with the dogs was outside with them. They were just without a leash. They were barking. I throw away the trash. I'm kind of like blinded by it. So there's a big pickup truck in front of my mom's garage. So I couldn't see anything. My mom was able to witness it. When I saw the car flashing the lights and the cars are running towards my son is when I reacted and ran and went to grab my son.
So did the dogs, were they barking or growling?
Yes, they were barking. They were running across the street. At no point, whoever was outside with the dogs made any point to restrain them, to call them, or anything.
So did they, again, I'm asking these questions because I can't see. You were down by the curb when you first, by the garbage cans, I'm assuming, when you first saw the dogs coming, right?
Yes.
So, and now I see your mom ran out, got your son, and then I see you following. Did the dogs follow you up towards your house?
Yes.
And what were they doing when they were following you up towards your house?
I kicked one of them so they can get away from me and my son. That's how it made contact with my ankle. And they still kept running towards us. It wasn't until my mom's partner came out and...
Is that the gentleman with the tank top?
Correct.
Okay, thanks. What is his name?
His name is Jose.
Okay. And he lives at this address?
Correct.
He's not here tonight?
He is not.
Your mom's not here tonight?
She is not either.
Okay.
No.
Okay, thank you. You have a seat.
Mr. Reichman, just watching that video just for a second, right before they start to run back, you can see the dogs coming at full speed across in front of that car. I don't know if Danny can try and pull that video back. You'll see the lights of the car light up the dogs as they're shooting off across the road. If that will help you kind of see how they were coming.
Need the video.
It's on the first one, Danny? You'll see the lights of the car, and you'll see the dogs.
Okay. All right. Give me a second. Okay. I'm going to find that the determination made by the city staff that these dogs were dangerous is supported by the evidence that's been presented to me this evening. I'm going to tell you why. The Florida statutes define a dangerous dog, sir, as follows. And this is if you want to look it up, it's in chapter 767 of the Florida statutes, and it contains definitions. And the definition of a dangerous dog, and there are several definitions, but one says when an animal is as unprovoked, chased, or approached a person, which we've got here, upon the streets, sidewalks, or any public grounds, which we've got here, in a menacing fashion or apparent attitude of attack, provided that such actions are attested to in a sworn statement by one or more persons and dutifully investigated by the appropriate authority. So let's break that down. Clearly, the dogs were running across the street. They were not under restraint. They came onto someone else's private property, and they were not provoked and they were not chased. I've got testimony this evening that behavior was done in a menacing fashion or an apparent attitude of attack. I have evidence that I have the sworn statement and the testimony by the victim, one or more persons, one person, and I have in front of me that this has been investigated by the appropriate authority, and that is the city of Deltona. So I'm going to make a ruling today that the city's determination is upheld by the evidence that has been presented to me this evening. Now, these dogs are not going to be put down, sir, but they are determined to be dangerous. Now, that's important. I'm not your attorney, but there's certain things that have to be done now when you let these dogs out of your house. And if they get out of your house again, and they are not properly restrained, and they do anything, the chances are very high that the next time, they're already declared to be dangerous, and the next time, if they hurt someone, you're looking at these dogs being destroyed. And I know you don't want that to happen. No, sir. Okay, so it's really important that you work with the code enforcement officer so that you fully understand what is required of you by the state law now that these dogs have been declared dangerous. Okay?
Yes, sir.
All right. Thanks for being here tonight.
Appreciate it.
Good luck with you. Okay, the next case is DEL 22-146, 2901 Howland Boulevard. This is a Massey case. Give me just a second here. It's an erosion issue.
Yes, sir.
So you ready to proceed?
Yes, sir. This is a Massey case. My name is Dennis Muse. I'm employed by the City of Deltona as a code compliance officer. This is a Massey case number DEL 22-146, the City of Deltona versus Cole FD Portfolio 3 LLC, care of Family Dollar Stores Incorporated. Property address is 2901 Howland Boulevard. Parcel ID number is 8130-391-30080. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to both to the property owner at the address list with the property appraiser's record. In addition, both the notices were posted at City Hall at least 10 days prior to the hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on May 25th that the property owner was given 60 days to comply. The owner did not come to compliance within those 60 days and has been receiving a fine of $150 a day since July 24th, 2022. As of today, the property has accrued a total fine of $4,650 over 31 days. The city is requesting that the fines continue at $150 per day. We have with us today the attorney, Kate Cooper, who would like to make a statement.
So the property has not been brought into compliance?
No, sir, it is not. That's as of today.
Those are photographs today?
This is as of today, that photograph.
Okay. Okay, very enough. Is there someone here for the property owner?
Good evening, Kate Cooper here on behalf of the Family Dollar property owners.
I'm sorry, ma'am. I couldn't hear you.
Kate Cooper here on behalf of Family Dollar property owners, 6921 Pistol Range Road in Tampa.
Okay, what do you want me to hear?
Honestly, it's an information gathering session for me. There's really no defense. I understand that the fines are going to continue to accrue. I was recently made aware that this issue is ongoing. I spoke with Officer Muse yesterday regarding the erosion issues. I drove over here from Tampa today. I went over to the property, took photographs myself that are pretty much the same as what you're looking at tonight.
Gotcha.
So I'm going to discuss with my clients, and we're going to get working on it.
Okay. Well, that's helpful. I guess the only thing I can say is that if this had just happened yesterday, your appearance here would be great. but it didn't happen just yesterday. This has been going on for a long time. Your client has been receiving these notices, and let me ask this question, because I'm always trying to do what's fair and what's right. Did they give you any explanation why they basically just ignored this for about 5 or 6 months?
Quite honestly, I try and act as a conduit when these types of things happen. Typically, it's debris issues, which I think this property also had an issue with, but that one's resolved. And things get posted on the doors. Sometimes managers don't escalate things up the chain, perhaps in the way they should. Notices get sent to corporate, and they don't go down the chain in the way that they should. I try and act as a conduit between the folks locally here in Florida on the ground and the folks up in Chesapeake and say,
Okay.
What do we need to get things done? Obviously, there's some sort of disconnect here. I spoke with Officer Muse. He says that the managers are trying to help, and it seems like their efforts, it doesn't seem to be an issue so much with the managers, but it might be some folks a little bit above them that I need to address and let them know that
Well,
this
here's
needs to
our
be taken care
concern,
of.
or at least I'm going to speak for myself, for my concern, and that is that someone's back there when at low light levels, could be an employee, could be a child, someone's going to get hurt. Because you could run through the photos again, and I'm kind of reiterating what I heard and what I said when this came back in May. Now we're almost in September. If you could run through the photos again, and you were out there, you know what I'm talking about. I mean, this is not a safe situation, and there's probably not lights out there. Yeah, there you go. And someone's going to get hurt. And this commercial property, and you guys are going to be getting certified mail from Morgan & Morgan, which is far worse than anything I can do or would want to do. So anyway, I'm not trying to make light of it, but you understand this is the city's concern. So I guess what I'm looking to hear is do you have any idea when in your world, working in these types of situations, what are you looking at as far as what you think they're going to do and when they're going to do it?
I need to be candid. Erosion isn't my specialty. I'm definitely a layman in that area. If it were something like debris or whatnot, I could say 30 days, no problem. We could get a vendor out there. I'm just not entirely sure what needs to be done.
Okay. Well, you understand this is what's called a Massey hearing. This is step 2. Step 1 already happened back in May. That's where there was a determination. I made a determination the property was in violation of the codes. The fine has been running for 31 days. It'll continue to run at $150 a day until it's resolved. But again, I'm going to reiterate, we're not here to take the money from Cole FD Portfolio 3. Thank you, but that's, it's nice getting money, but that's not what we're here for. I hope you can tell what I'm trying to say is we just want the property brought into compliance sooner rather than later. You're here. I can tell that tomorrow or this evening you're going to send a very strong email to your client about that they're losing money every day. I don't have a lot of discretion. Is there anything that specifically you can give me so that I can reduce the fine? But otherwise, it is what it is.
I think at this juncture it would be more appropriate to ask for time. I think time is the bigger concern in being able to have a timeline that's doable. I would request 60 days I know we still need to be in compliance and we're at stage 2. My bigger concern is the time factor and what needs to be done to address the erosion issues.
What is the city's position?
Mr. Reisman, Richard Lovett, just to remind you, when we had this hearing last time, they sent a representative up here, and that representative, and that was an attorney at that point too. I don't know if it's the same law firm or not, but they did send a representative here when we gave them the original time. That's why we gave them a lot of time to get it done.
60 days. Mm-hmm. See, that's what's giving me some heartburn here is that, again, this was the first hearing, and you were here, first hearing, and asked for 60 days. The answer would be sure, because I already did it.
Right.
But it's been now 90 days, and nothing's been corrected as far as this violation. And my opinion as a hearing officer is that's a dangerous condition. So it's not just a matter of an appearance issue. It's more than that. So I'm going to find, and the law's clear, you guys can come in and ask for reduction of fine, but I'm going to find the property remains in violation, and at $150 per day, 31 days, the fine's $46.50, and it's going to continue to run at $150 a day. I hate to do that, but and again, this has nothing to do with you, but someone's not paying attention, because 91 days ago, someone was here, and nothing's been done. and it's not giving me a whole lot of opportunity to be Mr. Nice Guy. So I'm not going to be. So anyway, if you just go back and tell, I mean, there's a process under Florida law to ask for reduction. You know, we hear those a lot. So that's fine. But I'm less concerned about the money than trying to create the incentive for this to be fixed. And for a business, the way you do that is you fine them.
Yeah.
So that's what we're doing.
I understand.
Okay. Thank you for being here tonight. Sorry you had to drive I-4.
Thank you. No, I understand.
Yeah. Okay. Appreciate you being here. Next case is DEL 22-235-3095T Oga Terrace. This is a permit issue, not a Massey case. Go ahead whenever you're ready, sir.
Okay. Okay, my name is Dennis Muse. I'm employed by the City of Deltona as a code compliance officer. This is case number DEL 22-235, the City of Deltona versus David and Susan Jakovich. This property address is 3095 Tioga Terrace. Parcel ID number is 8130-340-50060. This is the violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective actions, corrective action is you must obtain a permit for the addition to the rear of the property. Statutory requirements for the notification of hearing have been met by the notice of hearing and notice of code violation or sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at the property or on the property and at City Hall at least 10 days prior to this hearing. All the exhibits to this case, including photographs, have been marked and as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This was a proactive case that was discovered on August 23rd of last year. I could see the start of an addition to the rear of the property from the street. I checked the system, not finding any permit. A courtesy notice was left. Tenant Mr. Batista came to City Hall stating he was a contractor and would pull the permit, but would need an extension. Plans were submitted, but after some time and the holidays, a notice of violation was sent and posted at the property, February 7th, 2022. On March 22nd, permitting personnel discovered Mr. Batista was not licensed to do any contracting. Therefore, the plans for the permit were put on hold. Spoke to the property owner, Mr. Jakovich, stating he had another contractor that would sign off on the permit. The company declined, and the tenant decided to remove the addition. That was May 9th. Stopped at this location on June 12th, finding only a portion of the roof was removed. On August 10th, posted a notice of hearing, and to this day, August 24th of 2022, the rear portion was removed. The cement was still there, and no permit has been pulled or issued for that.
All right, so let me see if I understand it. So they started doing some work, didn't have a permit, went in, tried to get a permit, couldn't get a permit because they weren't licensed to get a permit.
Yes, sir.
They started taking down what they had started without the permit.
Yes.
Made some progress, but there's something still out there that needs to be removed.
Mr. Batista put in cement the full width of the house, from one side to the other.
And that requires a permit.
That requires a permit.
And that's still out there.
That's still out there.
And this Mr. Batiste, he's the former tenant or the current tenant?
He is the current tenant, as far as I'm aware. He's the current tenant.
Okay. Okay. So what is the city's request?
The city would request 30 days for the property to come into compliance or a fine of $250 per day to be imposed until such time the property owner was notified the city of compliance.
And what kind of time frame?
30 days.
Thank you, sir. Is anyone here for 3095 Tioga Terrace? Sir, if you could come forward, and again, and you've been sitting there a long time, but I do need your name and address, please.
Sure. I'm Daniel Batista. I live in 3095 Tioga Terrace. That's the house I live for.
Okay, great.
Okay, I moved from New Jersey. I'm a licensed contractor in New Jersey. I moved to Florida, and I bought this house. I don't use the bank because I have a private contract, so this is a legal contract, so I pay my mortgage every month. And when it comes to I have a small porch in the back, was like all deteriorating, water all over, the concrete's all cracking, it can hurt somebody. And we decided to do another one, only porch. But my wife, my ex-wife, with the ideas, put a little bit bigger here, a little bigger there. So when I see the thing, it was like huge. And I know I have to, as a contractor, I know I have to get the permit. So I hired an architect. So we did the blueprint. So in a couple of weeks, I received a notice from them. They already saw it. And they asked him get the permit. So I got the blueprint being refused like 8 times. Something wrong with my architect, so it being refused for 8 times, being like this for like over 6 months. So, but after in the end of the day, so we got everything like okay. So in the day I came to the city hall to get the permit, everything, to pay the fees. Because everybody so far knows I'm the owner, but I have a private contract. So everything, the homeowner, the actual homeowner, signed all the paperwork for me to do the job as a homeowner, not as a contract. So in the day I came to pay the fees and got the permit, somebody told me they got state law and I cannot do anything as a homeowner because I'm actually not a homeowner, registered homeowner, something like that. So, and I decided to not fight with the city anymore. I already spent in that thing. You saw that everything is about like $30,000 in material and labor. So I spoke with Mr. Dennis. And I say, Mr. Dennis, I already spent a lot of money, but I know it's not your fault. I just need to get this thing down the way I did it in my free time. So I've been like for a lot of stress. I got my divorce because of this, a lot of discussion about this. So I start doing little by little in my free time. So as a contractor, I work from Sunday to Saturday, and Sunday I have to do that job. So I never stops. So I finished last week, and I given a copy of the pictures. I have a picture right here if you guys don't have it, with the whole thing.
You want me to see it? Yes, sir. If you could give it to someone and they'll bring it up to me and I will look at it. Happy to look at anything you want me to see.
Yeah. So all the structural is down.
So I think all we're here on tonight is just the concrete.
Yeah, my point is, I plan the next year do the addition because I like the idea, and but my point is the concrete is not dangerous, it's not hurting anybody, it's not putting anybody in I don't think it's something like big deal. And next year, when I have to do it again, I know I have to redo the concrete. So when I hire somebody to do the concrete, just like I did it, so it come with a machine and remove the whole thing. Because if I remove that one here, I have to put something in my backyard. So I'm going to spend money again. So as long as I don't put any structure on the top, you know what I mean? I don't think this is a big deal. I mean, this can be there until I have next year, money again to do it again. But I want to do things right. You know, I want to cooperate. I mean, I just knock everything down you see there.
Let me ask a couple questions. You said
Sure.
that you're not the owner. Is the owner of the property David and Suzanne Jekovich?
Yes, they have over 1,000 houses in Florida.
Oh, okay.
So he's that's the point. Some people, I bought this thing online. I bought the house. I never saw the house. I bought talking to them over the phone. And,
You don't own this house.
I'm sorry?
You do not own this house.
Yes, I own the house, but I paid them directly. I have a private contract.
Okay, but you haven't received fee simple title to it.
No, I don't have the title. That's my point.
Right.
It's I have a private contract. I pay the mortgage every month, you know, but
Okay.
the house is still in their names.
Okay, because technically they're the ones that are on the hook for
I know,
everything that I do today.
I know. That's right. I'm, you know.
Okay, so I'm going to accept this. You've given me these photos. I'm accepting them. I've looked at them, sir. I'm going to have them marked as the Respondent's Exhibit A or 1. So they'll be with your file. They stay here because they're part of the record now. Is that okay?
I'm sorry, I can't hear
I'm
you.
keeping these photos.
Okay, sure.
Okay,
Sure.
Figured that was okay.
Sure.
Okay, here's the problem. I'm not disagreeing with you that this concrete is necessarily dangerous. That's really not the issue tonight. The issue is more of a simple issue. It's more of a procedural issue, and that is that when anyone comes into Deltona and is going to do some construction work, and you've heard this come up earlier tonight, you got to get a permit. And I think you tried to. You told me tonight that you tried to get the permit, and for a whole bunch of different reasons, and I accept all of them, didn't work out, and that's fine, but it's not really relevant to what this code violation is. And that is that you've got, under the code, you have two options. You either get the permit or take out what was put in that requires the permit. So really the issue tonight is, what's a reasonable amount of time for you, sir, or the property owner, which is you, but not technically, not legally, for you to get the permit or take the concrete out? And that's what I'm trying to determine right now.
Okay.
And I need your help so that we can find an amount of time that's reasonable for you to either get the permit or take the concrete out.
Okay, just to show you, I mean, I really want to do things right. When it comes to apply for the permit for the concrete, because I have to apply for everything, I have already done. So the frame,
It's
everything.
all gone. That's all gone.
Right,
Yeah.
but I'm saying the slab, the concrete, I call like a termite company. They apply 280 gallons of the chemical underneath that thing. So I did everything supposed to be done. But then the last day, somebody told me the only way to keep that concrete in there is I have to get somebody like an architect or engineer and take a responsibility about what they have underneath that thing. I say, come on, nobody gonna do that. You know, that's like impossible. There's an impossible task. So, I mean, I just asking you if you can keep it, because I'm gonna take it off. I have no problem to take it off. I understand this.
Remove the slab.
I want to remove this slab, but when I'm going to remove this slab, I want to build a new one with the right way.
How much time do you need to remove the slab?
Well, I'm planning to remove this slab and build another one next year.
So you're saying next year, it's almost September 1st. I mean, what do we?
Next year, like January, February, I'm going to start doing it again.
Okay. So if I give you 90 days, that would give you almost to the end of the year. 90 days to remove the slab or get a permit.
Okay.
Does that work?
Yeah, it works.
Okay. I'm going to give the gentleman 90 days, find this property is still in violation, 90 days to remove the slab or a fine of $100 per day. I don't want to fine you. You understand what I'm saying? You've heard me say this over and again. That's not what we're here for tonight.
I understand.
But we do need to make some progress. So in 90 days, you can get that slab out of there. Let this gentleman know the progress. Keep him informed. Sure. We don't want to impose the fine. It's not why I'm here. Don't want to do that.
Sure.
And you don't want it. So 90 days.
All right.
Okay. Thank you, sir. Appreciate you being here tonight.
Thank you.
Good deal.
Next case is 22-253-945 Vivian Terrace. This is a permit issue as well. Officer Meade,
Yes.
please proceed.
Okay, my name is Todd Meade. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22253. The City of Deltona versus Rosalia N. Menendez Mijares. The property address is 945 Vivian Terrace. The parcel ID number is 813011260070. This is a violation of the City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the roof added to the home. The statutory requirements for notification for this hearing have been met. The notice of hearing and notice of code violation were sent certified mail to the property owner of the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. I observed a new roof structure having been added to the home on April 4th. I reviewed the address for any case history to recognize if any permits were open for the added section of the roof. I made contact with the homeowner, and she shared with me her son replaced the old roof of her shed and attached it to the roof of her home. She allowed me to photograph the structure for case exhibits. I made contact with my supervisor to reach out to the homeowner to help explain the issues that were at hand. My supervisor was unable to make contact with the homeowner at that time in the field. The property was later posted for the notice of violation on June 10th. The homeowner will need to provide certified drawings to apply for the permit, and the case was escalated to the magistrate for noncompliance with no permit on August 2nd. The city would like to request 60 days for the property to come into compliance, or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
All right, let's be clear. So the property remains in violation, and the violation is that there's no permit that was applied for or received for the work that was being done and shown in these photographs.
Yes. Yes,
Okay.
sir.
Is anyone here on behalf of 945 Vivian Terrace? Last but not least. I'm just being, last but not least.
Yes.
Sir, if you give me your name and your address, please.
How you doing? My name is Marcos Mercham. I live in 881 West Warren Avenue, Deltona. No, it's Longwood, sorry.
So you're the nice son who added this on for his mother?
Yes, sir.
Okay, but you didn't get a permit?
No, sir.
Okay. Do you understand why you're here tonight?
Yes.
Okay. The city's saying that they want me to enter an order giving your mom, because she's the property owner, 60 days, and there's two options: either get the permit or take the improvements down. What say you?
I already spoke with the engineer. They can help me with make the project, the draw, like the blueprints, and bring it over here and get the permit.
So do you think 60 days is going to be enough for you to be able to get the permit?
Yeah.
Okay.
I will.
So you're okay with me entering an order this evening and giving your mom 60 days to get the permit, or a fine of $50 a day?
Yes.
Okay. All right. Do you have any questions?
No.
Okay. Thank you for being here today. Sorry, this has to go this way, but it looks like, you're here, you understand. That's the important thing. You work with this gentleman right here, make sure that he's kept in the loop, and then we'll be done.
Yeah, I've been working on it. It's just like a little bit lack of time and
I know. No good deed goes unpunished, but still, we do need to have the property brought in compliance.
I will
I'm going to enter an order that the property still remains in violation, giving you 60 days to comply, which is getting the permit, or a fine of $50 per day. Fair enough?
Yep.
Okay.
Thank
you very much.
Thank
Good
you, sir.
luck.
Thank you.
Do we have any more respondents present? Anybody? That's it? All right, we're going to go back, I think, to the beginning of the agenda then. Yep, 22150, it's a Massey case, Officer Scott. Got a bunch of them.
That's them.
Go ahead, sir, when you're ready to proceed. 22150.
Y'all did it. Should I continue them since y'all don't have the photos? They was put in there way before, about 350 something.
You ready to go, officer?
Can we put my cases on hold for a second and go with the other ones?
We can do that?
All right,
Absolutely.
thank you, sir.
So your case is 150, 151, 152, and 153.
Yes, sir.
And then I move on to another officer, okay? So we'll come back to that. That brings us to case number 22240. Sir, could you go ahead and just find, this is going to be case number 22240. You're going to pull for, to hold 4 cases, Officer Scott's cases, and those are all the remaining Massey cases, 150, 151, 152, and 153. Just put those aside for the time being, okay? And then we're going to scoot right into new business, which is 240.
Mr. Reichman, Myron Samigo, hearing clerk. We're going to withdraw DEL 22-266, the request for hearing by owner, due to the fact that the owner is not present.
Okay, well, hang on a second. We're jumping around here. Where are you?
DEL 22-266.
So that's withdrawn or just continued?
It will.
Do you want it withdrawn or continued?
Withdrawn, please, sir.
Okay, okay. Just so you know, so that's, we're jumping ahead. 22, it's the last one on there, 22-266, that's being withdrawn. Okay. Okay, so that's good. Progress. Okay, which brings us back to 22240, which is a regular new case, 1528 North Normandy, and it's outdoor storage. City ready to proceed. Officer Coulter.
Yes, sir. My name is Kristen Coulter. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-240, the City of Deltona versus Joseph Rose and Judith Ann Galloway. The property address is 1528 North Normandy Boulevard. The parcel ID number is 813-0033-20260. This is a violation of City of Deltona Ordinance Section 38-114, which states that furniture outside must be designed to be placed outdoors or stored inside a covered structure. In addition, storage of materials relating to residential use, children's play toys, firewood, brush, logs, or any other material intended to be used in fireplaces or other permitted burning facilities shall be permitted only in the rear yard to the rear wall of the home. Corrective action for said violation is to properly store or remove from the property. The statutory requirements for notification of this hearing have been met by. The notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was initiated proactively on March 6th, and a door hanger was left. A notice of violation was posted, and later a notice of violation was notice of hearing was posted on August 9th. Contact has been made with the resident. The property remains in violation. The city would like to request 30 days for the property to come into compliance, or a fine of $100 per day to be imposed until such a time that the property owner has notified the city of compliance.
Still in violation.
Yes, sir.
30 days to comply or a fine of $100 per day.
Yes, sir.
So ordered.
Thank you.
Next case, 22141. Officer Meade. This is a permit issue.
My name is Todd Meade. I am employed by the City of Deltona as a code compliance officer. This is case number DEL 22241. The City of Deltona versus SFR JV HD Property LLC, Tricon American Homes LLC. The property address is 541 Battersea Avenue. The parcel ID number parcel ID number is 813021080060. This is a violation of the City of Deltona Ordinance, Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the fence in the area around the home. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with their property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate in portrayals of what I observed on the day they were taken. I observed a fence on the property at 541 Battersea Avenue on March 13th. I reviewed the city's file records on the property and discovered no permit for the fence. A courtesy notice door hanger was left to initiate contact with the resident. I made an inspection on the property and made resident contact on April 19th. It was shared with me by the tenant that the house was occupied as a renter. The tenant provided the homeowner information, and it followed up with a notice of violation issued for the no permit on the fence and was sent out on May 16th. The certified mailing card received back on May 27th. There's been no contact by the property owner by phone, text, or email to the officer for the direction to meet compliance requirements at any time since the case was opened in March. The city would like to request 30 days for the property to come into compliance or a fine of $75 per day to be imposed until such time that the property owner has notified the city of compliance.
Still in non-compliance?
Still not in compliance, yes.
Heard nothing from the owner?
Nothing, no contact or any.
City's request will be entered in an order.
Thank you.
Next case is DEL 22243. This is exterior walls. Officer and Melinder. 22243, property address 923 Alder Drive.
My name is Jamario Millender. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-243, the City of Deltona versus Roy McKinley. The property address is 923 Adler. The parcel ID number is 813-017-130-020. This is a violation of the City of Deltona Ordinance, Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 304.2, which states that all exterior surfaces, including but not limited to doors and window frames, cornices, porches, trims, balconies, decks, and fences shall be kept in sound working condition and maintained in good repair. Exterior wood surfaces other than decay-resistant woods shall be protected from the elements and decay decayed by painting or other protective covering or treatment. Corrective action for said violation is to repair or replace damaged exterior walls and soffits. The statutory requirements for notification of this hearing have been met by the notice of hearing and the notice of code violation that were sent certified mail to the property owner at the address listed at the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. The notice of violation was actually posted on May 24th of 2022. On May 6th, 2022, a prospective buyer by the name of Brian called into City Hall to inform us that he was in the process of getting the warranty deed transferred to his name within the next 2 to 3 months. As of August 24th, 2022, this is still currently in the works. On August 8th, 2022, I conducted a walk around with the other prospective buyer, her name is Hannah, to essentially give her a visualization of the lingering compliance issues at the property. Roy, Brian, and Hannah have been cooperative and have kept me up to date with how things are going at the property. The city would like to request 60 days for the property to come into compliance, or a fine of $50 per day on the 61st day to be imposed until such time that the property owner has notified the city of compliance.
What was the per diem fine?
$50 a day.
Okay, let me ask a couple of questions. I see that this is the first of 5 cases that you've got this evening on the same property.
Yes, sir.
Officer Melender. The property owner is identified as Roy McKinley. Have you had any communications with the property owner, Mr. McKinley?
So we had initial conversations with Mr. McKinley, and then so basically what it seems like is they're trying to do a private sale from Mr. McKinley to the 2 other individuals, Brian and Hannah. I can't remember the last names right now. And essentially that's still in the process. When I've asked them about it, they're telling me like they seem to be getting closer to, I guess, that finish line, if you will. But I guess they're still in the process of trying to.
Because tonight there's 5 cases, and this could be a pretty good chunk of money per day.
Yes, sir.
Against do you know if this property is homesteaded?
That I'm not sure.
Okay. So do you have the contact information for Mr. McKinley?
Yes, sir.
Is there any reason why, do you know why, and no one's here this evening on these cases?
I do know that the 2 prospective buyers, so the female, she's having some health issues and is actually in Texas. I actually talked to her today, and her husband is with her out there in Texas. I'm not sure the whereabouts of Mr. McKinley.
Okay. And this owner, does he live on the property?
No, sir. The house is vacant and is currently being worked on. I actually talked to the contractor today as well.
Okay. I'm going to find that on this case, this is 22-243, which is the exterior walls of the property remains in violation. Give them 60 days to comply or a fine of $50 per day.
Yes, sir.
Next case is the same property, 22-244, excuse me. This has to do with accessory structures.
My name is Jamar Millender, and I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-244, the City of Deltona versus Roy McKinley. The property address is 923 Adler Drive. The parcel ID number is 813-017-130-020. This is a violation of the City of Deltona Ordinance, Section 18-5, Section 302.7, which states all accessory structures, including detached garages, fences, and walls, shall be maintained and kept in a good repair and in sound structural condition. Corrective action for said violation is to repair or remove the decks in the front and backyard. Statutory requirements for the notification of this hearing have been met. The notice of hearing and a notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. And then essentially the same narrative as the previous one.
Still in violation?
Yes, sir, still in violation.
Nothing's changed as far as your prior testimony?
So.
On this issue, the accessory
On
structure?
this one. So I will say when I went out there today, the deck in the front has already been essentially broken down. And when I arrived, he was working on breaking down the decks in the backyard as well. And he
It's
said
still in violation. There's not full compliance.
Yes, sir.
So what is the city's request as far as compliance and a fine?
I was saying the same thing as the first. I would say 60 days,
60 days.
for the property, or $50 on the 61st day. That's all.
So ordered. Thank you, sir. Next case is DEL 245, same property address. This has to do with the pool.
Yes, sir. My name is Jamaria Millender. I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-245, the City of Deltona versus Roy McKinley. The property address is 923 Adler Drive. The parcel ID number is 813-017-130-020. This is a violation of City of Deltona Ordinance Section 303.1, which states that swimming pools shall be maintained in a clean and sanitary condition and in good repair. Corrective action for said violation is to either drain the pool of water, or the water must be chemically treated to remove algae, and water should be clear water and sanitized. The statutory requirements for the notification of this hearing have been met by the notice of hearing and a notice of code violation that were sent certified mail to the property owner at the address listed in the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and is submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. And then the same narrative as well.
All right, so let me ask some questions about the property. The pool looks like it's in those photographs.
Yes, sir.
Is that pool,
This is today.
is that pool secure? Is there a fence around it that's gated or a screen that's gated and locked?
So I'm actually going to get to the screens, but there is a fence around the property, so that is secure in that way. But the actual screens, that's another case here. That's another issue. with the property.
So the fence, let's talk about the fence. And she said there's going to be, I'm going to hear a lot about the screening in a little bit. Is the fence secure? I mean, is it all the way around the backyard, or
Yes,
can
sir.
people get in there?
Yes, sir. It's secure all the way throughout the backyard, and then they have stoppers behind the fence so that you can't just push it open.
All right. So you're not telling me, you're telling me you don't see any safety issues?
No, sir.
So is the city's request the same, 60 days to comply?
Yes, sir.
Okay. 60 days to comply, it's still in violation, or $50 per day. So ordered. Okay, we're getting there. The next case, DL 22246. And that's the same property, and this has to do with zoning.
Yes, sir. My name is Jamaria Millender. I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-246, the City of Deltona versus Roy McKinley. The property address is 923 Adler Drive. The parcel ID number is 813-017-130-020. This is a violation of City of Deltona Ordinance Section 110-101B, which states that zoning regulations are designed to lessen congestion in the streets, to secure safety from fire, panic, and other dangers, to promote public health, safety, morals, and general welfare, to retain productive agricultural areas, and to facilitate the provision of essential government services such as transportation, water, sewage, disposal, schools, and parks. The violation, City of Deltona Ordinance Section 110-801, which states that every part of every yard shall be open and unobstructed from the ground up, except as otherwise permitted by this chapter. Corrective action for said violation is to obtain a permit or variance or remove the structures from within the property setback. The statutory requirements for this notification of this hearing have been met by the notice of hearing and the notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken.
So we're talking about the shed on this case.
Yes, sir.
So what is it about that shed that's a code violation?
It's right now it's in an easement.
Okay, so it's located in an improper location?
Yes, sir. And from what sorry.
Do you have any idea why it's got a street mark on it?
No idea. But from when I was talking
There's
to
no one living in there, I hope.
No. And actually, when I was talking to the contractor today, he was saying their plan for that is to just tear it down.
Sure. All right, so that's what I see is the way it looks today.
Yes, sir.
60 days?
60 days.
Okay, so it's still in violation, 60 days to comply, or $50 per day fine. Okay, last case on this property is 22247. We got a pool enclosure, as promised.
My name is Jamario Millender, and I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-247, the City of Deltona versus Roy McKinley. The property address is 923 Adler Drive. The parcel ID number is 813-017-130-020. This is a violation of City of Deltona Ordinance Section 303.2, which states that all private swimming pools, hot tubs, and spas containing water more than 24 inches in depth shall be completely surrounded by a fence or a barrier of at least 48 inches in height above the finished ground level measured on the side of the barriers away from the pool. Corrective action for said violation is to fix the screen enclosure surrounding the pool. The statutory requirements for this notification of this hearing have been met by the notice of hearing and the notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. Same narrative.
All right. What I see is what it looks like today?
Yes, sir.
Okay, so that it's got a screen enclosure just without any screen in the enclosure.
Correct.
Okay, this one's a little different. I'm going to give them 20 days to comply.
20, okay.
Or a fine of $100 per day.
Okay. Yes, sir.
You might want to let them know that.
20 days or
20 days to
$100.
comply or $100 per day fine.
Yes, sir.
All right, I believe we're moving on. Fresh victim here. 22248, 2173 Clearwater Drive. This has to do with accessory structures.
Yes, sir. My name is Jamario Millender, and I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-248, the City of Deltona versus Thomas and Fanea Wong. The property address is 2173 Clearwater Drive. The parcel ID number is 813-045-470-050. This is a violation of the City of Deltona Ordinance, Section 110-827C1D, which states that accessory buildings and structures other than lawn ornaments and fences built in accordance with this chapter shall not be located in the front yard forward of the edge of the principal dwelling or beyond any side street yard setback on lots less than 2.45 acres. On lots of 2.45 acres or more, accessory uses and structures other than swimming pools and their decks may be located in the front yard and the side street past the main building line, provided that they are set back a minimum of 100 feet from the front yard and the side street yard and 75 feet from any interior side lot line. Corrective action for said violation is to remove the canopy. The statutory requirements for this notification of this hearing have been met. The notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed in the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing.
Can you leave that photo up, please? Okay, I got some questions in general about this one. So the subject of this particular case is that blue canopy.
Yes, sir.
And there's a picture in there where it's actually not up.
Yes, sir.
So what are they using it for?
So he was using it to fix the lawnmowers. There were like about 2 or 3 lawnmowers that were sitting outside this property, and he was using it, I guess, to fix them and whatnot. So as of today, he actually came into compliance.
Okay.
However, we would like to find him in violation at the time of the posting and to be in compliance as of today so that we can set this up as a repeat offender if the violation recurs.
So let me ask just a couple more questions.
Yes, sir.
So you've spoken with the property owner,
Multiple times.
and he knows that he can't do this again?
Yes, sir. This was over 60 days old, and he, like I said, he just took it down.
Okay, so just so we're clear for the record, just the basis for this case is that this is an accessory structure.
Yes, sir.
This question for whomever with the city. This is just something, a little cover that you might see someone use at the beach. You might see someone use it in their front yard or their backyard. I'm to feel comfortable with, entering the order. In the code, is structure defined? And why is this a structure that would be subject to this code 110.827 C1D?
Because it is vertical above the ground.
Is that consistent with the definition for a structure within the code?
Yeah, the structure definition is very broad.
Okay.
I don't have it right here in front of me. I apologize.
I know, I'm putting you on the
Your Honor.
spot, but I mean, I don't want us to get in a situation wherever we drive down the street and someone's got one of those little covers out over a kiddie pool that we're going to cite them for violating, having an accessory structure that's in violation of the code.
Understood. I think in this particular case, from what I'm hearing, is this has been there this isn't a temporary type of.
Oh, so he keeps this up?
From what I saw, yes, sir.
Okay, that's important, because I thought maybe he'd put it up and he'd take it down and put it up.
No, this is like over 60 days, and I talked to him about 3 times.
So this is just, it's you drive down that street, that's what you see every day.
Yes, sir.
When was that case first opened with this?
Back in June.
I'm going to find that the property's in compliance now, but was in violation beyond the deadline cited in the notice of violation, and the next time this occurs at this property within 5 years, it would be a repeat violation. I think we have one more case for you, sir, and it's DEL 22255, outdoor furniture, 2173 Clearwater Drive.
Yes, sir.
Same property, right?
Yes, sir, same property. Okay. My name is Jamario Millender, and I am employed by the City of Deltona as a co-compliance officer. This will be case number DEL 22-255, the City of Deltona versus Thomas and Fania Wong. The property address is 2173 Clearwater Drive. The parcel ID number is 813-015-470-050. This is a violation of the City of Deltona Ordinance, Section 38-114, which states that furniture outside must be designed to be placed outdoors or stored inside of a covered structure. In addition, storage of materials relating to the residential use, children's play toys, firewood, brush, logs, or any other material intended to be used in fireplaces or other permitted burning facilities shall be permitted only in the rear yard to the rear wall of the home. Corrective action for said violation is the items must be properly stored or removed from the property. The statutory requirements for the notification of this hearing have been met by the notice of hearing and a notice of code violation that were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. The notice of violation was actually posted on June 26th of 2022. I have spoken to Mr. Wong on 2 separate occasions and have explained the violations to him. Both times he stated that he understood the issues and agreed to come into compliance. Nothing has been done in the last 60 days. The city would like to request 14 days for the property to come into compliance or a fine of $100 a day to be imposed until such time that the property owner has notified the city of compliance.
Is the property still in violation, 14 days to comply, or a fine of how much?
$100 a day.
So ordered. All right, are we back for our Massey's? Yes, sir. All right, this case is DEL 22150, 1223 West Wellington Drive. This is a Massey case involving a permit. Officer Scott.
My name is Jeff Scott. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 22150, the City of Deltona versus Crown Property Acquisition LLC. The property address is 1223 West Wellington Avenue. Parcel ID is 8130010702000. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation was sent and certified mail to the property owner at the address listed with the property's appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on May 25th, 2022 that the property owner was given 7 days to comply. The owner did not come into compliance within those 7 days and have been receiving a fine of $100 a day since June 2nd, 2022. As of today, the property has accrued a total fine of $8,400 over 84 days. The city is requesting that the fine continue at $100 per day.
Any communications with the property owner?
No, sir. I received an email 2 weeks ago that basically was saying that we're harassing them.
So how do you know today that they're still in violation?
There's no permit on file on our end.
Say that again?
There's no permit on file on our end for that.
That's good evidence. All right, so ordered. A fine of $8,400, 84 days. So let me ask this question. It looks like it's a corporate owner? Crown Property Acquisitions?
Yes, sir.
And why did they...
Oh, actually, that was another case on the other case. So the Crown Royal, I have heard no contact from them at all.
No contact at all?
No, just the tenants, and they no longer live there. So.
Okay. So $8,400, 84 days, $100 a day. They're still in violation. They haven't gotten their permit.
Correct.
Okay. And you haven't had any contact with this commercial owner?
No, sir.
Okay. Okay. The next case is 22151. Officer Scott, this is, looks like you got 3 of them on this property.
Yes, sir.
Massey's. This one has to do with the permit.
Yes, sir. My name is Jeff Scott. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 22151, the City of Deltona versus Robert and Deborah Tincher. The property address is 1602 Providence Boulevard. Parcel ID is 8130720500170. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation was certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at the property at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on May 25th, 2022 that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and have been receiving a fine of $50 a day since June 25th, 2022. As of today, the property has accrued a total fine of $3,050 over 61 days. The city is requesting the fine continue at $50 per day.
Still in non-compliance?
No.
Still no permit?
No permit.
Okay, this is the one I'm assuming that you got the email from
Yes,
the owner.
yeah, I received an email from
That was
them.
from either Robert or Deborah Tincher.
Yes, sir.
And was there any communications with the Tinchers other than that email?
No, sir.
And that email said,
Basically, we harassing them and
okay, all right, I can live with that. So I'm going to find that the property still remains in violation, and the fine is accrued at $50 a day for 61 days, for a total fine as of today of $3,050, with the fine to continue to accrue at $50 a day.
thanks, sir.
Next case is DEL 22-152, another Massey case, same property. This one has to do with debris. Before you get started, is this occupied, this property occupied?
Yes, Robert and his wife, they live.
Owner occupied?
Yes.
Okay, got it.
My name is Jeff Scott. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22152, City of Deltona versus Robert and Deborah Tincher. Their property address is 1602 Providence Boulevard. Parcel ID is 8130720500170. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation was sent certified mail to the property owner at the address listed with the property's premises record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on May 25th, 2022 that the property owner was given 14 days to comply. The owner did not come into compliance within those 14 days and have been receiving a fine of $100 a day and since June 9th, 2022. As of today, the property has accrued a total fine of $7,700 over 77 days. The city is requesting that the fine continue at $100 per day.
So ordered.
Mr. Reichman.
Next case, last case. What?
Mr. Reichman, Richard Love, I'd just like to add one thing on this case.
I'm sorry, what's that?
Just for the record, I just want to add on this one that we're going to be looking at moving forward with an abatement on that property.
The 22-152 debris?
Yes, sir.
Okay. So, I've already asked this of Officer Scott, but this is 3 cases, same property, obviously adversarial property owner combative. Has there been any communications between the city and this property owner other than with Officer Scott?
No, sir, only with Officer Scott that I'm aware of.
Okay. All right. Last case is 22-153. It's a mass case, same property. This is dealing with number of vehicles. Let's go out strong.
All right. My name is Jeff Scott. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22153, the City of Deltona versus Robert and Deborah Tincher. Their property address is 1602 Providence Boulevard. The parcel ID number is 8130720500170. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on May 25th that the property owner was given 14 days to comply. The owner did not come into compliance within those 14 days and have been receiving a fine of $50 a day since June 9th, 2022. As of today, the property has accrued a total fine of $3,850 over 77 days. The city is requesting that the fine continue at $50 per day.
If you all remember, on these cases, were these folks here for the original?
No, they wasn't.
They were not? Okay. So they weren't here
But
then?
I spoke with Robert that day, the first hearing, and I explained everything to him. He asked, was it mandatory, and I told him that's on him if he wanted to show up. I just told him I would read the case in and
And he
go
didn't
from
give
there.
any indication in that communication about compliance or?
Yes, that's where the 14 days and the 30 days came from, because
Okay,
we.
got it. All right, I'm going to find this property remains in violation as far as number of vehicles as of today?
Yes, the trailers and the boats are still
I'm
there.
going to find the property remains in violation, and the fine is a total of 77 days at $50 a day for $3,850 for the fine to continue at $50 per day. Folks, we are out of little green folders up here, so I'm assuming that means that we're done,
Yes, sir, that's correct.
unless I'm mistaken. All
No,
right.
sir.
Hearing no more cases from the city, we are adjourned. Thank you very much, folks.
Thank you.